Fairchild vs. Glenhaven Funeral Services, 2002, is a leading case on the element of causation in English tort law. It concerned malignant mesothelioma, a deadly disease caused by breathing asbestos fibers. Hello and welcome to Landmark Case Laws Simplified. Buckle up as we explore the fascinating world of Fairchild vs. Glenhaven Funeral Services together. Mr. Fairchild actually brought together 3 different appeals with pretty similar facts. In each one, a worker, or their family, developed mesothelioma, a deadly cancer caused by asbestos. Over the years, these workers had been exposed to asbestos dust at different jobs, working for several employers. Every one of those employers had failed in their duty to keep their people safe from a hazard everyone knew about. Here's the catch: medical science just couldn't say which job, or which employer, was really to blame for the cancer. Mesothelioma can start from just a single asbestos fiber, and nobody could tell which exposure actually did it. So, when the claimants tried to sue, the Court of Appeal shut him down. Why? Because the usual, but for, causation test said they couldn't show that any single employer's breach was the one that caused the disease. The House of Lords took a different approach. They overturned the previous decision and created a big exception to the old rules about proving causation in tort. Their thinking was pretty clear. If a group of employers all exposed someone to a dangerous substance, and it's impossible, because of science, to prove which one's failings actually made the person sick, that person can still get compensation. The key is whether a defendant's breach of duty materially increased the risk of the disease, and then the disease actually happened. Why bend the rules? The Lords said it was a matter of basic justice. It just didn't sit right for someone to suffer a clear legal wrong, only to be denied compensation because science can't pinpoint the exact cause. Letting all the employers off the hook would basically gut the point of having a duty of care in the first place. Sure, it might seem unfair to hold a specific employer liable when it's not 100% certain they caused the harm, but the Lords decided that was less unjust than leaving injured workers with nothing. That said, the House of Lords made it clear this wasn't going to be the new normal for every case. For the Fairchild rule to apply, a few things need to line up. Every defendant must have breached their duty to protect the worker from harm. The harm must come from the same agent, like asbestos, that all the breaches involved. And, crucially, it has to be impossible, and not the claimant's fault, to prove which breach actually caused the injury, just because of the limits of current science. Later on, the House of Lords took another look at this rule in Barker v. Chorus, 2006, and tweaked how it worked. Let's meet in our next adventure on the Baker v. Chorus landmark case. Thanks for watching.